The webinar will begin in 2 minutes. The webinar will begin in 1 minute. Welcome everyone, and thanks for joining us for today's webinar, The Dangers of Do-It-Yourself Estate Planning, Lessons from Aretha Franklin's Estate. The webinar will last approximately 20 minutes, and at the end, you will be given an opportunity to receive supporting materials by email free of charge to you. You will also be told how you may email questions related to today's content to the presenter. Today's presenter is Linus Sugis. Linus worked for a Chicago-based insurance company in various roles, including Director of Advanced Sales and as Chief Marketing Officer. He ran and sold a successful estate planning law practice. Linus also writes the publication Think About It, founded by life insurance industry guru Steve Weinberg, and Linus regularly speaks at industry events. His latest book, Sell Out, The Busy Entrepreneur's Guide to Transferring a Closely Held Business, written together with a CPA and a business broker, is now available for sale. Linus will draw on his legal, tax, and life insurance background and his practical experience for today's webinar. And here he is.
Thanks, Jennifer, and hello, friends. I'm glad you've joined us today. We switched topics on you for this month. We were going to talk about qualified charitable distributions. We'll talk about those next month. But this month, I thought we'd cover something that's a little bit more timely, certainly is interesting, at least from my perspective, and I hope from your perspective as well. And I think it's something that's relevant to our customers. Aretha Franklin did some do-it-yourself estate planning, apparently. Her relatives are in court trying to figure out exactly what that estate planning means. And I think there's some lessons there for us and for our clients that we should take to heart, and we should use the example of Aretha Franklin to better educate our clients. We will talk next month, as I said, about qualified charitable distributions. I want to say today, we might spend a little bit more time than usual. Usually I end up talking about 15 minutes, maybe 20 minutes about the topic, but there's some stuff here in the Aretha Franklin estate that may make us go a little bit longer. So forgive me in advance for that. So let's get right into it, and let's start with some of the main observations about do-it-yourself estate planning. Look, those of us who are in the financial services business and in the life insurance business, we understand the importance around planning for the distribution of stuff at death. We deal with beneficiary designations all the time. If you've been a regular listener to these webinars, you've heard us talk about the importance of getting beneficiary designations right so that death time transfers can happen in a predictable and orderly way. That's only part of the estate planning story. The other parts of the estate planning death time transfer story have to do with titling of assets properly, things like joint tenancy, things like living trusts, and also wills and revocable trusts are all a key part of death time planning. Our clients sometimes are tempted to do death time planning with will documents, especially themselves. They might go to a stationery store if they're a certain age and get a fill-in-the-blank form for a will. Or if they're a little bit younger, they might decide to use software that would allow them to create their own will, either online or with a freestanding piece of software. Now, why would our clients do this? Well, I think there are several reasons. First of all, it's perceived as being less expensive as going to a professional. A piece of software might cost 50 bucks. Going to a professional might cost easily 10 or 20 times that. An individual probably feels like they have more control over the process if they do it themselves as opposed to going to a lawyer. And then, some people just have kind of an irrational fear of lawyers, much like some people have an irrational fear of doctors, and they're intimidated around the process of working with them. And so for any one of those reasons, people might choose to do their documents themselves, so to kind of, a do-it-yourself kit. The problem, of course, is that because people don't engage in will drafting regularly, the odds are is they're going to get it wrong. They're going to get something important wrong. And Aretha Franklin, if these are her documents, is no exception to that. So according to probate documents that have been filed in Michigan, in the years before her death, Aretha Franklin apparently tried to draft her own will documents. She tried to draft them in her own handwriting. Now, unfortunately for her 4 sons, her children, right, there are a fair number of ambiguities in those documents that it's either going to take family agreement or it's going to take a probate judge, to sort out. There's a fair amount of uncertainty. And so as we go through the will documents that Aretha Franklin apparently drafted prior to her death, keep those ambiguities and difficulties in mind, because to me, they're the lessons for our clients. So a little background on Aretha Franklin. She needs no introduction, but I'm going to give a brief one anyway. So Queen of Soul, passed away last year in August at the age of 76. Amazing hits in the 60s and 70s. Respect, Chain of Fools, Think, Natural Woman. At the time of her death, during her lifetime, she had 4 children, all of whom survived her. Clarence Franklin, Edward Franklin, Teddy Richards, and Kekaf Cunningham. And at the time of her death, she was not married. And at the time of her death, she apparently left 3 handwritten documents. And so Sabrina Owens, earlier this year, went to probate court in Michigan, which was the place of Aretha Franklin's domicile, and she filed a petition. Sabrina had been named the personal representative of Aretha's estate, and she filed a petition in probate court. And in her petition, her lawyer said that on the date of her death, that Aretha Franklin apparently had left 3 handwritten wills, that the heirs of Aretha Franklin's estate had all seen the documents, but they were unable to agree on what those documents meant and how they were to be applied on the probate assets in Franklin estate. And so Sabrina Owens was unable to decide her own self how to resolve some of the ambiguities and some of the things surrounding the documents. And so there's going to be a process by which the heirs either aggressively or peaceably fight it out in probate court and either agree or don't agree about the documents. Now, we were able to see the actual documents thanks to a story by the Detroit Free Press, which is linked here. The Free Press article alerted us to the fact that the documents existed. And then, of course, they provided links to the actual documents themselves that have been filed in the probate court. And so if you're interested in examining the entire documents yourself, you're welcome to follow the links. And if you email us after the seminar, the webinar today, we'll send you a copy of the newsletter article that covers a lot of the same ground and also has the links that are referred to here on this slide. So this is what we're dealing with. This is one page of one of the documents, the November 30th, 2010 document, excuse me, the June 21st, 2010 document that was apparently handwritten by Aretha Franklin, which is apparently her own handwritten will. And you can see that there are a lot of crossouts, a lot of arrows, a lot of spelling that you have to kind of try to figure out, and kind of a stream of consciousness approach to what happens with Aretha Franklin's stuff. Go ahead and take a minute and take a look at this and see how at least it's a minor challenge to try to sort out what she wrote. So the bad news is that all three of the documents are done in a similar style, and that they're hard to read quickly. The good news for us is that we've kind of gone through them and taken our best guess as to what Ms. Franklin actually said in the documents, assuming these are valid in hers. And so we'll talk about those in a second. Let's talk about probate, first of all. The probate process is the process by which the court supervises the transfer of stuff. And the reason the family's in the Michigan probate court is that they're trying to figure out what Aretha Franklin directed with regard to the transfer of her stuff, whether her documents are valid, and if they are valid, how they're going to apply to the stuff that Aretha Franklin left or had in her own name at the time of her death, because that's what probate applies to, and that's what the will documents, if they're valid, would apply to. So probate is the court supervision of the transfer of stuff, and that's not necessarily a bad thing, except if you're a family that wants to keep things private, in which case things are public. That's why we have an opportunity to look at these documents, is because Aretha Franklin's probate estate is a public court proceeding, and the documents are available to the public if you want to go down and see them. And so for somebody who wants privacy, going through the probate process isn't necessarily the best thing to do. And so there are ways to avoid probate, the most popular of which with lawyers is putting together a living trust, which apparently Aretha Franklin decided not to do. Some of the other downsides of probate is that it takes a while to finish. The process is deliberate. It takes pretty much at least a year from start to finish, unless there's a fight. Here, there's likely to be a family fight over some things, and so it may take years before this is ultimately resolved. And then, of course, the last thing is that probate can be expensive. Anybody who's got a claim against the estate that isn't agreed to by everybody probably has to lawyer up. Lawyers, God love them, I are one. They are expensive, and a lot of the estate could be dissipated with the family having a disagreement over how Ms. Franklin's estate is going to be distributed. Ultimately, if the family doesn't agree, the probate court will decide, the probate judge will decide, because the probate judge is perceived to be impartial and will apply the law fairly in this case. And one of the other parts of the probate process is that it's an opportunity for creditors, any creditors that Ms. Franklin have, is to put their claims with the court so they get paid before the assets are ultimately distributed to the heirs. Now, we've talked already, or alluded to the fact already, that Aretha Franklin had a handwritten will at the time of her death. Not every state recognizes the validity of a handwritten will. Most states do recognize a will that has been formally drafted and formally witnessed, sometimes also formally notarized, and in some states that's the absolute requirement for a valid will. But other states, including Michigan, do recognize the validity of handwritten wills in the testator's own handwriting can be valid if they meet some of the other criteria for valid wills. And so Michigan does recognize the validity of handwritten wills, and part of the question is, are the other conditions satisfied with regard to Aretha Franklin's will? And here's the part of the Michigan statute that says a holographic will, that is a handwritten will, can be valid. It says that it's valid if the testator's signature is on it, the document's material portions are in the testator's handwriting, and some other stuff can be admitted into evidence for the probate court to be considered if overall the will meets those requirements. And so it'll be up to the judge to exercise judgment and sort it out to figure out what's valid and what's not. What are some of the generic issues with holographic wills? Why aren't they valid in every state? Well, I alluded to one thing earlier. I mean, people are amateurs on will drafting for the most part. And so if they're not estate planning attorneys and they try to do a holographic will, odds are they're going to miss something. Some of the language they use might be legally ambiguous. Their lack of understanding over the probate process may have them try to include stuff that wouldn't be effective. And they may not address things that need to be addressed in a holographic will. And so from my perspective, it's always preferable to have our clients go to work with a professional to have the job done right. And that's one of the lessons here from Aretha Franklin's estate. So what are some of the specific issues with Aretha Franklin's documents? Well, I mentioned the fact that there are 3 documents. We don't know whether they're all valid copies, first of all. Secondly, we don't know for a fact that these are in Aretha Franklin's handwriting. Third, we don't know whether Aretha Franklin was legally competent to make a will at the time of any one of these 3 documents. And then, what we're going to quote from the documents coming up, we think we've got it right, but we're not sure we're right. And you need to remember that as we talk about some of the provisions, because we don't want to create a false narrative. We just want to demonstrate how instructive this situation is for us as we work with our clients. So what are the 3 documents we're talking about? Well, we're talking about Aretha Franklin's handwritten note dated October 20th, 2010. That was in a locked cabinet. The June 21st will, we saw one page of it earlier. It's got the most details, and it was also in the locked cabinet. And then there was another document found underneath a couch cushion, which was dated March 31st of 2014, which also has detailed testamentary provisions, but it's written a little bit differently from the 2010 long document. And the question is, partly the question is, was it intended to revoke the 2010 document or to simply supplement it? that's not really clear. So here's what the 2010 will says. So it says, at least this is their best interpretation, my wishes are, in the event of my demise, that all my property, and she lists her property, Turtle Lake, Redstone Bend, Scenic Court, and something called would-be property of Teddy. We don't know what that is. And she specifically excludes a property called 2074 Wickford Court. And then that will goes on to say the 2074 Wickford Court property is intended for KECAF. And Aretha Franklin apparently intends for KECAF to have an allowance that would allow him to live there. And she specifies certain accounts out of which the allowance will come to KECAF. And then I mentioned earlier, this is kind of a stream of consciousness document in that in the same kind of provision, she says that royalties are to be divided between her kids, and she identifies certain accounts that royalties come into and where they are coming from. And so the effect of these words on those royalty income streams, and exactly how that's going to be sorted out, that will have to be answered. Apparently, she wants her personal property to be divided equally between her kids. Her son Clarence apparently has special needs, and she wants her other three sons to look after him. She has earmarked in her will document a certain amount of money every week to go to support Clarence, but it's not clear whether all three of her sons are trustees of a trust for Clarence, exactly how that's going to work, because she wants Clarence's guardianship to go to Sabrina, her niece, who ends up being the executor. Clarence has some responsibilities to let his brothers know what his needs are, and to tell them how much money that he needs. And then there's an odd thing, that's the last thing here on this page, that Aretha apparently wants KECAF and Edward to go get business administration classes and get some kind of degree in order that they can manage the money on behalf of their brother. And Aretha Franklin doesn't say what ought to happen if KECAF and Edward don't go and get those degrees, or what, whether they should be handling Clarence's money or not. There's a lot of ambiguity, as you can see, even as you sort through the document and hopefully get the right language. It's not clear exactly what the contingencies ought to be. And so we've kind of summarized, in the 2010 will, what the ambiguities are. What if the accounts that she specifically refers to aren't owned or weren't owned by Ms. Franklin at her death? What about KECAF and Edward and the requirement to take business administration classes? Is there a valid trust created for Clarence in the will? It doesn't say anything about a trust. It just says an allowance, and the brothers are supposed to pay the allowance. What does that actually mean? Does the document actually create trusts for KECAF and for Eddie? Because there's some words in there that say that as a condition of getting money or controlling certain money, they've got to do certain things. If that's correct, if it does create a trust, who's the trustee? What are all the terms? And then the document also apparently refers to a living trust in its next to last paragraph, and we don't know if there is in fact a living trust. So that's an ambiguity. So there are plenty of issues with the 2010 will. There's also a 2010 letter written later in the year, which makes clear from Ms. Franklin's perspective, again, if it's in her handwriting, that she doesn't want any of her ex-spouses, any of the children's fathers, to have any rights to any of her estate. She explicitly revokes any will or will draft that might have been drafted prior to 2010. And that's the purpose of the October 2010 letter. Now, the October 2014 will, which was found under the couch cushion, not in the locked cabinet, has just a little bit different language. So she bequeaths the Wickford courthouse to Edward, her primary residence to her son Keycalf, her home in Palmer Woods to Teddy. And so it's a different distribution than was set forth in the 2010 document. There's some ambiguity as to exactly what it says about her royalties, whether it goes to her granddaughters or to her sons, or for the benefit of her sons. The responsibility with regard to Clarence is apparently divvied up between Eddie, Keycalf, and Teddy. Deferred money, I'm not sure what that means. That is different from royalties, is to be split evenly between her three sons. What that means for how much that goes into the trust for Clarence is not clear. And then she talks about account balances as of the date of the 2014 document. She tried apparently to name Keycalf the executor under the 2014 document. Not sure what happened. Sabrina is acting as executor, personal representative in the actual court filing, but so it's not clear what that means. Royalty accounts from certain places to be split evenly among her sons, certain kinds of bank accounts to be split evenly among their sons, but she wants Brenda and Sabrina to get $200,000 each from her recording account balances, and that's not clear whether it's from a bank accounts, whether it's from royalties, exactly where that money is coming from. And then Carol Ellen in Memphis, who is her half-sister, gets $50,000 apparently, and it's not clear which account that is supposed to be coming from. So, and then it goes through personality and who's supposed to get that stuff. So, it's ambiguous as to whether or not the 2014 will completely supersedes the 2010 will. If it does, it doesn't deal with Clarence in the same detail as the 2010 will. And so, I think it's fair to ask the question, did Aretha Franklin mean for the 2014 document to supersede the 2010 one because it was found in a different place and because it wasn't quite as robust? And then, a lot of unanswered questions about the personal stuff, about the trust for Clarence and how everybody's taken care of and where certain monies are coming from that Aretha Franklin apparently wanted to leave as bequests to people other than her kids. So lots of ambiguous stuff that if a lawyer had drafted these documents apparently wouldn't have come up with. And so to make a long story even a little bit longer, let's wrap this up and think about the takeaways from this. First of all, I think the most important takeaway is most people, particularly if they've got a fair amount of stuff, should work with an estate planning attorney to create their wills and trusts. Miss Franklin was a legendary singer, but from my perspective, she made a poor estate planning attorney. And so her documents weren't great. She probably would have been better served to go to an estate planning attorney and have the documents drawn up in a more formal way. And our clients should take that lesson as well. If they aren't in the business of doing estate planning documents for a living, they're probably better off hiring an estate planning attorney to do their testamentary documents. The second lesson is revocable trust should have been considered here. particularly if privacy was important, and I suspect it was for the Franklin family. Third thing is, well, to be explicit, not only in will documents, but in beneficiary designations. As I said, we've talked about this before. Beneficiary designations can control a lot of wealth for a lot of people. For many people, it's the most liquid wealth is going to be controlled by a beneficiary designation. And so taking time and effort for us to get those designations right is really important. Testamentary documents, wills, and trusts need to be drafted with compliance with local law, another reason why an attorney is needed. And then for our clients, there's a real value in working together as a team where everybody talks to each other. One of the things that we didn't talk about in Ms. Franklin's documents is that she had a fair amount of distrust for some of her financial advisors, including some of her lawyers. And it's hard to work with those people if you don't trust them. And so putting together a team where everybody's pulling in the same direction is really, really good for our clients. And our clients want to see us playing nicely with each other, those of us who are financial professionals, playing nicely with the attorney and the accountant so that everybody is working toward the client's best interest. And so that's really optimal from a client's perspective. So at the end of the day, Aretha Franklin decided to do her own will. She got 3 testamentary documents. The court's going to have to sort out what those documents mean for her heirs. Our clients are going to be tempted by the same thing. We should do our best. Here we can hold up a specific example to talk them out of doing their own documents. And for Aretha Franklin, with better planning on the front end, perhaps some of the pain and uncertainty of her estate, certainly some expense could have been avoided. I want to thank you all for joining us today, and I'll turn the program back over to Jennifer to wrap it up. Jennifer?
Thanks, Lennis, and thanks for joining us today. As a reminder, if you would like to receive supporting materials, feel welcome to email me at asktheexpert@advancedunderwriting.com. Again, that's asktheexpert@advancedunderwriting.com. You may also email questions related to today's webinar. For more information about the services that Advanced Underwriting Consultants offer, including phone consultation and newsletter licensing, feel welcome to contact me at 615-224-1291. Again, that's 615-224-1291. And please join us for July's webinar entitled Reconsidering Qualified Charitable Distributions. Thanks again, and best wishes for continued success.